Good morning, everyone, and glad you all could join us today for our beginning of our second month of the presentations of our Title 101 classes. I'll be leading off this morning discussing the Recording Act, and I'll be going for approximately 40-45 minutes or so, and then Brian will be following after me to discuss powers of attorney. As Margaret and Karen said, if you guys have any questions, please use the features available on this program to raise your hand or send a chat message to Karen, and she'll get the message to me, and we will try to address them as we go forward. And as I go through different parts of the presentation, I will be asking if there's any questions to give you guys a chance to jump in. So starting with the Recording Act, if you want, Karen, please go to the next slide. This program, by the way, so everyone knows, the host actually has to turn the slides, will be turning the slides for me. So sometimes if you hear me say turn to the next slide, it's because I'm not actually controlling the slides this morning. So the Recording Act is dealing with complications that arise when the same property is conveyed to two or more different grantees. So the example given is you see Mr. Smith conveying White Acres to Mr. Jones on October 1st, and on October 15th, he conveys it to Ms. Connor. And who gets the property when this is done, when it's conveyed to two different people, Mr. Jones or Ms. Connor? Okay, next slide, please. So in the beginning, under the common law, once the first conveyance occurred, sorry guys, I was hearing a phone ringing in there, so I stopped a second. So under the common law, once the first conveyance occurred, the transferor no longer had any interest in the property, so he no longer had anything to convey. So under the common law, the first one to get the property will be the owner of the property. Of course, the problem with this rule is it does nothing to encourage the recording of deeds or to protect innocent purchasers from the dirty dealings of the original grantor or the original owner. Therefore, we have the Recording Act. Next slide, please, Karen. So the purpose of the Recording Act is to establish a statutory rule of priority among conveyances to determine which party prevails when the same property is transferred to multiple people. Second purpose is to protect subsequent purchase against secret and unknown conveyances. And the third purpose is to preserve an accessible history for each title so it's clear on the record of who owns the property. Next slide. So through the different states, there's different types of jurisdictions that deals with different types of recording statutes. And the three primary ones are, first, there's a race jurisdiction, and the race jurisdiction is basically the first to the courthouse wins. The first to record the deed wins. The second is a notice jurisdiction, and it kind of takes the opposite approach to that. It's saying that if a property is conveyed to a grantee and the deed was not recorded by the first party, then the subsequent grantee is going to win, because the idea being that they had no notice of the original conveyance. In other words, the person that it was conveyed to first had the option to get it recorded. If they didn't get it recorded, and if you're in a notice jurisdiction, it's protecting the subsequent purchaser of the property if they paid value and had no notice of the original recording. Georgia combines those two into what the third category is, and it's called a race notice jurisdiction. And this means that a prior unrecorded deed loses its priority over a subsequent recorded deed from the same vendor when the purchaser takes such deed without notice of the existence of the prior deed. So the key to this one is you have to take notice the second purchaser has to take the property without notice of the existing one, meaning the first one was not recorded, and then you also have to record first. And one of the keys to this, the subsequent purchaser has to be a bona fide purchaser in order to get protection of the recording statutes. A subsequent bona fide purchaser prevails over an earlier purchaser if and only if the subsequent purchaser did not know about the earlier transfer and the subsequent purchaser's deed was recorded before the first purchaser's deed. So it becomes a question of not knowing about the first transfer of the property and paying consideration for the transfer. The second part of the bottom of the slide, it talks about a bona fide purchaser must pay fair consideration for the property without any knowledge or reason to have knowledge that the seller had previously conveyed it. So that gets us into the point, what provides knowledge that the seller had previously conveyed the property? And there's three different types of notice that I want to bring to your attention here. First is actual notice. Actual notice is when it can come in different varieties, but it is basically when someone tells you about the earlier transfer. Sorry, I just got locked out of my computer a second. Okay, so the actual notice is, again, when you have actual notice, someone tells you about the transfer, or you have other reasons you actually know about the transfer. The second type of notice is constructive notice. Constructive notice is basically the notice that is given from the recorded deeds. So if someone records their deed before yours, that gives everyone constructive notice that someone else owns the property. And the third type of notice is what's referred to as an inquiry notice. Inquiry notice is when basically there is sufficient notice given to excite the attention and put a party on inquiry. And if you're put on that, then you are said to have knowledge of anything that you inquiring about it would determine or might have led to. We will talk further a little later about more on these notices. I wanted to point out that, again, to be a bona fide purchaser, you must pay consideration for the property, and you must not have notice of the previous transfers. And those previous transfers could be either actual, constructive, which would be a prior deed being recorded, or inquiry notice. Okay, we're going to look at some examples to illustrate these different points. John sells Sweetwater to Susan on October the 10th by deed. On October 15th, he sells the same property, Sweetwater, to Sam, also by deed. Sam records his deed first on October 16th before Susan, and Susan records on the 18th. So it was sold to Susan first, then to then to Sam, but Sam records it before Susan. So who wins in that instance? Well, in Georgia, under the race notice, Sam would prevail over Susan because he is a subsequent bona fide purchaser for value who did not have notice of the earlier sale to Susan. Susan, of course, even though Sam would win the title, may have recourse against the original purchaser to sue him for her money back. But under this scenario, Sam would actually prevail for title. What if Susan records her deed before the second transfer to Sam happens, however? Well, this changes the scenario because now we're talking about Sam having constructive knowledge of the conveyance. So she no longer will be considered a bona fide purchaser. In that instance, Susan would win because she recorded first, because that again would give Sam constructive notice. And this illustrates the need for a title exam because the title exam is the way you determine whether or not there is constructive notice out there. So before people buy property, they are expected to do a title search. The first deed, if it's recorded before the second sale, the second seller is presumed to know of the first sale, as a proper title search would reveal that. Even if the second buyer did not know of the first sale, this is said to only be because of the second buyer's negligence in not completing a proper title search and the second buyer therefore not being worthy of being considered a bona fide purchaser for value because of the constructive notice that is provided by the title examination. Of course, this begs the question, and we'll talk about it. I'll talk about it a little bit later. But what about the gap period? And for constructive notice, you basically ignore the gap period, and it's the first party that records that's the bona fide purchaser that wins. But we will discuss a little bit later in the presentation the gap period and some of the issues that arise with that. Hey, our next example is John sells Sweetwater to Susan on October the 10th, but then on October 15th, he conveys it to Sam. Sam did not know of the earlier sale to Susan. Susan records on the 16th. Sam records his deed on the 18th. Sam was a subsequent good faith purchaser for value, but Susan recorded her deed first. So who wins? And going to the next slide, you can see that in a race notice jurisdiction, the more important policy concern is to encourage the prompt recording of deeds. Therefore, a second bona fide purchaser is allowed to prevail against the first purchaser if and only if they record first. So the second purchaser must record first, and in this case, he did not. Susan recorded first, so Susan would prevail under this scenario. One more example to illustrate these points. We got a Bob owner pledging his farm and giving a deed to secure debt to his aunt, and he executed the deed to secure debt, but the aunt did not record the deed to secure debt. Bob then sells the farm to Catherine. At the time of the sale, Catherine is not aware of the debt owed to the aunt or the deed to secure debt, and Catherine pays fair market value for the property. So it asks, is Catherine a bona fide purchaser for the property? And in this instance, because Catherine does not know of the original purchase and she paid fair market value, she is a bona fide purchaser. And note that this one changes the scenario a little bit because we're talking about a deed to secure debt. So you have a bona fide purchaser taking the property free of a deed to secure debt because the deed to secure debt was not recorded, and she acquires the property without knowledge. Going to the next slide, we change it up a little bit, and it says that the Aunt Moneybags learns about the pending sale to Catherine and decides to record the security deed. Now, the bottom one is one we're concerned about, who wins in a race notice jurisdiction, and in that instance, again, under the other scenarios we mentioned, the first to record would win. So if Aunt records first, then Catherine would take the property subject to the aunt's deed to secure debt. To answer the initial questions at the top, a race jurisdiction, clearly the first to record wins. So if the aunt records first, then Catherine would take subject to it. But if Catherine records first, Catherine would have the property free and clear of the deed to secure debt. And in this instance, that will be both for the race and the race notice, since Catherine is a bona fide purchaser. In a notice jurisdiction, that would be changed a little bit, and Catherine would win as long as the deed to secure debt was not recorded at the time of the sale to Catherine. On to the next page. Changes the scenario up a little bit and asks, well, what if Bob deeds the property to his niece, Catherine Purchaser, as a gift? Is she a bona fide purchaser? And that completely changes the scenario now, because Catherine paid no consideration for the property, so she is no longer considered to be a bona fide purchaser. So because the property is being gifted to her, even if that deed of gift gets recorded before the deed to secure debt, the deed to secure debt would still be valid and the property would still be subject to it. Now, this is talking just between these two parties. It's certainly possible that there could be additional conveyances and documents being recorded out of order, and there may be a subsequent bona fide purchaser that could change this scenario. But as between these parties, if it was a deed of gift and no consideration, then clearly Catherine would take subject to the deed to secure debt. But what if Bob owner informs Catherine about the deed to secure debt at the closing table? Well, that changes the scenario because now Catherine has actual knowledge of the deed to secure debt. So if she has actual knowledge, even though she pays money for the property, she would take subject to the deed to secure debt because she's no longer a bona fide purchaser. Okay, that's kind of the first part of the presentation dealing with recording. The first part of my part of the presentation dealing with the bona fide purchasers and the recording statute. So it would be a good time to stop and ask if anyone has any questions they would like to submit before going on to recording requirements and discussing transfer and intangible tax. Does anyone have any questions about Thought I heard someone. Anyone have any questions?
I do.
Okay.
Well, you were talking earlier, the race to get the in Georgia, since it's me who is doing the goal, and don't they have an obligation?
Ginger, I apologize, but I can't hear you very well.
Oh no.
Try again, please.
What I was saying is, in Georgia, isn't so the attorney is doing that I'm seeing somebody running to the courthouse for the document.
I'm sorry, Ginger. It's not legible. It's not coming through well on the microphone, and I'm unable to hear what you're saying. If you'd like maybe to type it in to see if Karen can get it to me, I'll be happy to respond, but I can't.
Okay, I will.
Karen, did anyone else have any questions that were typed in?
No, that looks like that was all for right now.
Okay, and again, I apologize, Ginger. I just cannot understand at all what you were saying there on the microphone. So, okay, next we're going to move on to the recording requirements. And these are the requirements to get a deed recording of record in the state of Georgia. There must be a name and address of a natural person printed at the top of the first page of the document, stating to whom the document is to be returned after recording. Now, what's interesting there, Georgia is an attorney state for deed preparation, but the deed preparer, the attorney that prepared the deed, is not required to include their name as the preparer of the deed in Georgia to get it recorded, only the return to information. The name may be on the left, center, at the right part of the page. It must be at the top. And at the bottom, it says there must be a 3-inch blank margin at the top of the first page. But do know, kind of out of custom in Georgia, oftentimes you will see at the top left hand of that 3-inch margin, the return to information may be there, as long as on the top right hand of that 3-inch margin, there is information for the clerk to stamp the recording information. And I'm not aware of a deed ever having been rejected by including the return to information even in the top 3-inch margin, as long as it's on the left-hand side of the page. And that seems to be more by custom. Okay, attestation requirements. First, let's discuss what it means to attest and compare that to an acknowledgement. And Georgia seems to be kind of unique in this when you have documents that are sent out of state to be notarized. And the distinction is, for a document to be attested, that means that it must be signed in the presence of the witness and the notary for a deed and certain other documents. The distinction between that and an acknowledgement is, if a document is acknowledged, it says that a party appeared before the notary and acknowledged that they executed the document. But it does not say on most acknowledgements that the document was actually signed in the presence of the notary. And on Georgia deeds, it's, you know, at the top of the deeds or beside the signatures, it says signed, sealed, and delivered in the presence of. So if you use that and just have the witness and notary to attest the deeds by filling those blanks out, that of course suffices and is in acceptable forms for recording for the attestation. But if you use, and if documents are sometimes, you know, are sent out of state, and if a notary out of state uses their own notary forms, and if that notary form is an acknowledgement and does not clearly say that it was signed in the presence of the notary, that is where you run into it not meeting the Georgia attestation requirements, not being in recordable form, and even if it is in recordable form, not providing constructive notice, as the Gordon case shows that we'll discuss here in a few minutes. So regardless of how a deed, security deed, and certain other instruments affecting title are prepared before these documents are sent to be executed, they must be filed for record in Georgia, executed by the grantor, and attested by an officer and the notary public as set forth under Georgia law. When it's a notary public, the notary must affix the seal. Note at the bottom there it says deeds merely signed by the grantor but not witnessed, or binding between the parties but not entitled to be recorded. Moving on to the next page. If no specific statute requires the document to be attested, note that an acknowledgement alone is okay. So kind of the default is in Georgia, certain documents can be recorded if they're acknowledged unless there is a statute that says they have to be attested, or if they have to be attested by both a notary and an unofficial witness. And I referenced the code section there, 44.2, 14, and 16, to indicate that, you know, a lot of documents are perfectly fine to be recorded without meeting these attestation requirements. But certain documents, and this is not meant to be a complete and exhaustive list, but these are the ones that I am aware of, do require documents to be attested before both the notary and an unofficial witness. And that is a deed, and I'll make reference to the code section where that is set forth: a deed to secure debt, a lease, an option, cancellation, and a power of attorney. To be recorded as a separate independent document must be attested as a deed. Again, if you have a document other than these, good chances are that those could be recorded without having to be attested before a notary, and a witness and acknowledgement likely will suffice. Also note with an affidavit, a lot of times you'll see with an affidavit that it's only signed before a notary and not a witness. And again, the reason is there's no separate statute with an affidavit requiring it to be signed before both a notary and a witness, so a notary alone suffices for an affidavit. Okay, going to the next page, the post-closure has brought you a security deed which was signed by the debtor. However, it lacks both an official notary's attestation and an attestation of an unofficial witness. The security deed has been filed for record by the clerk, and you're able to pull it up on the GSCCA. What do you need to do? And this gets us to the United States Bank National Association versus Gordon case that basically says if a document is acknowledged but not properly attested, it does not provide constructive notice to subsequent purchasers, even where the security deed is actually recorded. So very important when you get back your title reports, if you see in the chain of title that a document was not properly attested, and then there is an issue because if it's not properly attested under the Gordon case, it is not providing constructive notice, and therefore, as we discussed earlier in the slideshow here, if it doesn't have constructive notice, that is one of the types of notice that, you know, may prevent them from becoming a bona fide purchaser or protect the previous transfer, you know, from being a bona fide purchaser. So this is very important, and we oftentimes, you know, run into issues or not comfortable insuring when we have an acknowledgement in the chain, especially if it's a recent transfer. And so we certainly look at those on a case-by-case basis to see if there any way we can get comfortable to insure, but oftentimes you cannot, and we do require corrective documents often for those types of transactions. On to the next slide. Your examiner has brought to you the attached security deed for review of the attestation and execution. Note at the bottom there it says the instrument was acknowledged before me, but again it does not say that it was signed in the presence of the notary. So that is the issue that does not meet Georgia's attestation requirements, and it should not be eligible for recording without it being corrected. So we answered that question, is it in recordable form? It should not be in recordable form. And does it provide constructive notice? Under the Gordon case, it does not provide constructive notice. Okay, the next slide. Security deed was signed by the debtor and the notary, but the line for the unofficial witness was left blank. However, a waiver of borrower's rights was signed by the debtor and an unofficial witness as incorporated the innovative part of the security deed. Is the security deed in recordable form, and does it provide notice because the waiver was properly signed and incorporated into the security deed? Okay, next slide, please. So this is the Wells Fargo versus Gordon number 2, which basically the court rejected Wells Fargo's argument that the security deed was in recordable form and providing notice because the waiver was properly signed. To understand what Wells Fargo was saying here is, even though the deed to secure debt was not properly attested on the signature line of the deed to secure debt, it did not say that it was signed in the presence of the witness and the notary. The deed to secure debt incorporated by reference the waiver of borrower's rights, and the waiver of borrower's rights was properly attested. It had a witness and a notary that was signed in the presence of. So the argument was, well, since the waiver of borrower's rights is incorporated into the deed to secure debt, does this not mean that the deed to secure debt itself should be in recordable form? And the court said no, the actual security deed itself, not counting the waiver, must be in recordable form. And what else is interesting in this is that the court also basically concluded that this did not even provide inquiry notice, since it did not provide constructive notice, since the deed to secure debt was not in recordable form. And by looking at the waiver of borrower's rights alone, which was the only part of the document in recordable form, you could not tell what the description of the property was. So since that document that was recorded did not provide the notice, the court determined that not even inquiry notice was triggered by this. Do note that the Gordon case, going to the next page, please, Karen. It says here that's prescribed by statute in these cases. The same principle of execution and attestation applies to all deeds of conveyance filed for record in Georgia. And from the title perspective, that's basically our stance, and we look for strict compliance with this. But it is worth noting that the Gordon case has really not been decided outside the bankruptcy context. And that is important in at least one important part. A bankruptcy trustee is not entitled to have actual notice, or is not considered to have any type of actual notice. So, there might be some argument to be made on these types of cases when it is outside the bankruptcy context. But from the title perspective, until that is decided, any of these documents that do not meet these requirements, we basically, are taking the position that if they have a defect and were not properly attested, that it is problematic for title. Going to the next page, we talk about different ways that this can be fixed. It can be done with a corrective deed or a modification agreement. It can be done by an affidavit of a subscribing witness, may be recorded, or you can have a declaratory action, a quiet title action, to try to fix these defects when the deeds were not properly attested and have still been recorded of record. Be a good time to ask for questions. Does anyone have any type of questions about deed attestation, acknowledgement, how the Gordon case affects that before we move on to transfer tax? Okay, if no questions, I'm going to go ahead and jump into the transfer tax. Transfer tax is basically said to be $1 a thousand. More specifically, it's $1 for the first 1,000 and 10 cents for each $100 or fraction thereof, based upon full consideration less any outstanding liens. Deed of conveyance, of course, must be accompanied by a real estate transfer tax declaration form. This is completed on the GSCCA website, filed there, and a hard copy printed out that must accompany the deed for recording. Note in Georgia, I'm sure most of you are aware, under the standard real estate contracts, that the buyer typically pays the transfer tax in Georgia. And the other thing about transfer tax that I'll point out to you that's not mentioned here, occasionally you may run into a situation where property is located in different counties, and it's on one deed. And you may have a meets and bounds description that says the below described property is located in Fulton and Cobb County, described as follows. When that happens, there is a provision under the code that allows for an affidavit or the deed to state what percentage of the property is located in each county, and that has to be placed either on the deed or by affidavit, and then the amount of transfer tax is split between the counties. Some important transfer tax exemptions. This is not all the exemptions, but these are, the ones that probably come up most often. A deed of gift is exempt from transfer tax. A lease is not subject to transfer tax in Georgia. If the United States, the state of Georgia, or any agency or political subdivision of either is a party to the transaction, no transfer tax. Transfers in connection with the divorce have no transfer tax. A few others: deeds of assent, first transferee at a foreclosure sale, division of property among joint tenants or tenants in common, all exempt from transfer tax. Okay, recording of security deeds. Security deeds are required to show the maturity date and the debt secured, and all requirements for recording of deeds also apply to deeds to secure debt. So, most importantly, those are the two big things on the deed to secure debt: being certain that it meets the recording requirements as a deed, which includes being properly attested, and showing the maturity date and the amount of the debt that is secured. And of course, the maturity date in Georgia is crucially important to determine if it is a long-term or a short-term note that would trigger intangible tax, leading us to the next slide. Under OCGA 48661, there is an intangible tax on long-term notes. Long-term note being notes that fall due more than 3 years from the date of the instrument. The amount of the intangible tax is roughly said to be $3 a thousand. It's actually $1.50 for every $500 or fraction thereof. There is a cap of $25,000 on a deed to secure debt. Payment is required at the time of delivery of the security deed. Note that there are penalties if the deed to secure debt and tax is not paid in recording within 90 days from the date of the instrument. And these penalties are actually rather substantial. The penalties are 50% of the amount of tax that is due, along with interest. So if you have a situation, and the deed to secure debt is not recorded within 90 days, and if there's a lot of tax due on that deed to secure debt, this can be a substantial penalty. Failure to pay is a bar to foreclosure, which can be removed by paying the tax along with the interest and penalties. One other thing to mention here is if it's a short-term note, but the deed to secure debt indicates that it gives the borrower the option to extend it beyond a 3-year period, at the option of the borrower, that is considered to be a long-term note, subjecting it to intangible tax. Next slide, talking about exemptions from intangible tax. These are not meant to be all the exemptions, but these are some of the ones that come up the most often. The United States, the state of Georgia, or an agency of political subdivisions, a party, federal credit union, state of Georgia chartered credit union, or a church is the grantee, no intangible tax. Or if the instrument does not secure a note, such as sometimes you'll have a deed to secure debt that says it secures a guarantee agreement. In those cases, the property should not be subject to an intangible tax. However, I will caution you to be careful on some of those that, if they secure a guarantee agreement, there are some clerks that really look at that in a restrictive manner, and they may try to charge you an intangible tax. I know I've had some experience in Cobb County where they really may challenge those when they are secured by a guarantee agreement, and they may say that the intangible tax is due. There is a provision under the Georgia Comp Rules and Regs 56011 8.16 that allows you to pay intangible tax under protest if the clerk is trying to charge you intangible tax and you do not believe that it should be due. It's important to note that this must be filed and recorded at the time that the deed to secure debt is recorded and paid. That is, the protest must be filed at that time. It cannot be filed later, but it must be filed with the deed to secure debt. The money is then paid into the clerk of court, who holds it in an escrow account until the ruling is made by the Department of Revenue. Okay, going on to the next page, dealing with modifications, renewals, extensions, and modifications. If there's a refinance for a long-term note, and if it's between the same parties, then there should be no intangible tax that is due. Watch out, though, if there has been an assignment from the original lender. So if you had a situation where the original lender has assigned the note, most clerks, I think, is going to tell you that intangible tax is due, even if the refinance goes back to the original lender, since they're no longer the holder of the note. As long as the modification does not add any new money, there is no need to pay the tax again. A couple things there to look out for is if there has been an assumption agreement. There are some, within the last couple of years, Department of Revenue rulings where there was an assumption and modifications that indicated that a new borrower was assuming the note and modifying it, even though there's no new money, because it was an assumption agreement. That does trigger the intangible tax. Also, look out for modifications that extend the maturity date beyond 3 years from the original note date. In those instances, that likely will trigger intangible tax because the clerks will look back to the date of the original note. So, for example, you had a deed to secure debt that secured a note for 2 years, so no intangible tax was paid when it was recorded, but then you have a modification that extends that note for 2 more years. So since from the date of the original deed to secure debt goes beyond the 3-year period, that will likely trigger the intangible tax. But if there's a modification with no new money, absent those couple of outlying exceptions, there should be no intangible tax that will be due. Going on to the next page, the intangible tax affidavit. This deals when there is property in multiple states. If you have a note that is secured by property, both in the state of Georgia and in another state, you can do an affidavit to attach to the deed to secure debt, showing the value of the property in Georgia compared to the value of the property in another state, and then you would only pay the intangible tax on a portion of the property, it being the Georgia pro rata value of the total property that is securing the debt. The holder of the security instrument, meaning the lender, is the one that signs this affidavit, not the borrower. And note that this works when the lender is a non-resident of Georgia. If the holder of the note is a Georgia resident, they will pay the full intangible tax, just as if all the property was located in Georgia. Okay, next slide, please. Multi-county property. If there's an instrument if there is a long-term deed to secure debt and it secures property that's in multiple counties in Georgia, you would also do an affidavit to attach, assigning the value of the property based upon tax assessed values between the counties. This affidavit then would say how much of the tax is payable to each county. That affidavit will be attached to the deed to secure debt, and the intangible tax would be accordingly split between the two counties. Getting near the end, I want to ask if anyone has any questions on transfer or intangible tax before we close it up talking about gaps. Any questions at all about transfer tax or intangible tax?
I don't see any questions, or there's nothing in the chat.
Okay, thank you, Karen. I'm going to go on real quickly. I know I'm almost out of time here. Recording gap. You should promptly record all documents that, immediately after closing. The slide here is saying no later than 2 working days from the date of closing. Of course, you should record on the date of closing if possible. You should update title, especially for commercial transactions, close to closing, typically within 3 days of closing, for commercial transactions. And for the larger commercial transactions, it's always advisable to have a gap indemnity agreement. We don't require those necessarily for 1 to 4 family residential transactions, the gap. But I would suspect that most owners' affidavits will have some gap indemnity language in those. And certainly under the COVID-19, if for any reason recording is not available in a county, we are requiring gap in those situations. And if you run into a situation where recording is way back due to this COVID-19, in those situations, please be sure to use a gap indemnity agreement at closing. I think Clayton County, for example, I believe their good through date is back sometime in February. So next slide, the pre-closing gap is proper procedure to conduct a date down of title, covering the period from the date and time of the commitment to the date and time of closing. An issue agent should keep in their file a record confirming when that was last done for audit purposes. And the last slide, I wrote as gatekeeper. We're the gatekeepers of the public record established by Georgia's Recording Act. With that responsibility comes the obligation to ensure its accuracy and allow for the free flow of property, which is vital to our state and the national economy. Does anyone have any questions as that concludes my portion of the presentation? Does anyone have any questions?